what's the difference between copyright, patent, and trademark?
Patents have to be applied for. They don't arise just by themselves, and they are restricted to the jurisdiction in which the patent is given and to other territories linked to it by treaty, and they last at most for 20 years. Trademarks also have to be registered. They don't just arise. You have to apply for a trademark, and you have to prove that that mark is in continued commercial use, and every 10 years you have to reapply to renew it. And if it's not in commercial use, it just lapses and anybody can use that name. Copyright has become something totally different and vastly more monstrous. Copyright arises on creation. You scribble a line of verse on your table napkin, the copyright is yours. Copyright lasts for a huge amount of time, for your lifetime and then 70 years after that. Or if you're doing work for hire for a corporation, 95 years from publication. Copyright also includes sub-rights or associated rights that are much more complex than those involved with trademarks or patents, because if you own the copyright, you own the translation right, the right to abridgment, the right to anthologies, the right to adaptation on screen and stage, and on and on and on. So copyright really is the big thing, and patents and trademarks are relatively apply to a relatively restricted number of things in ways that are easy to understand and better administered than copyright.
And we should say your book is basically tracks the history of copyright. When did these three ideas, in terms of the idea of like owning ideas or owning devices or owning so-called intellectual property, did they develop simultaneously, or what was at the forefront of that?
No, they did not develop simultaneously, and I must correct you, none of these laws allows you to own ideas. Ideas are not privatized, at least not yet, and not formally, even if some people are rather clever at using these laws to make it seem so. Patents and copyrights sort of have a common early history in 15th century Venice, when one of the most important privileges granted by Venice was indeed for a printing press, which was a kind of patent kind of thing, except that it was making books. And so the idea of licensing books through a system of privileges accompanied the spread of the printing press throughout Europe and the rest of the world. But the idea of copyright, of there being a particular property right not in books as physical objects, but in what's in the book, not the ideas, but the form of expression, that's a creation of the 18th century. And it's only in the 19th century that a clear distinction began to be made between copyright in written and visual art and patents for inventions and discoveries. So the two paths begin together in Venice in the 15th century, but they move apart into quite different regimes between the late 18th and middle of the 19th century. Trademarks are probably the most ancient. I mean, in medieval Europe, innkeepers with signs of the King's Arms on the pub could indeed prevent anybody else opening a pub down the street with the same sign. So they have a long and informal history. But trademark legislation has increased vastly in the last 50 years.
What role, because we have this, patents and, to some extent, I guess, copyright are mentioned in our Constitution. What role does the U.S. have in setting the terms for copyright internationally at this point?
None at all. The United States had copyright laws from the 1790s, but they were largely unused. It was too much of a bother, and in any case, US copyright laws did not recognize any copyrights in works by non-citizens until the 20th century. They didn't fully internationalize US copyright till 1976. So the US was an outlier, much resented by the British and the French for 150 years. And it has always been following on behind the copyright, or the creep forward, if you like, of copyright that took place in Paris and in London, and then, of course, in Prussia and other countries. The United States did not sign the Berne Convention of 1886, which is the basic sort of framework for international copyright, until, guess when? 1989. Just 5 years before Albania. However, since then, the US has turned the tables and has introduced much more extensive, deeper and broader protection for created work. And by piloting the scheme whereby, since the US had joined Berne, it made every other country that wanted to be a member of the World Trade Organization also sign up to Berne. So you could say that that's one way in which the US has taken the lead. The way in which the US is in the lead is simply that by insisting that software programs and computer code are literary works, and I'm not joking, that's what the preamble to the 1976 copyright says, that computer programs are literary works. By doing that, it's created, of course, a vast proprietary software industry which it dominates and for which it extracts a huge tribute from the rest of the world every year.
Let's talk about that, Eric, because I'm curious as to, like, what switched within the U.S. regulatory scheme, or the what choices were made, from a political economy about that. Was it the idea that people could see that computer software was going to move forward, and there was a desire to allow corporations to be able to sort of milk that? I mean, what was it that changed?
Well, I'm afraid, Sam, it isn't really a story of a profound thoughtfulness, or indeed even of a well-directed power grab. It happened in the most anecdotal and idiotic way imaginable. It goes back to the early 20th century, when player pianos were all the rage. You know, those mechanical pianos that played a tune that was controlled by punched paper tape, that when it went round, it made the keys turn. Because sheet music was then copyrighted, or copyrightable, music publishers objected, and they said that these punched paper tapes are actual copies of our sheet music, and this player piano is infringing our copyright every time a restaurant owner puts the thing on to entertain his guests. And there was a lot of squabble about it, the outcome of which was the special arrangements made for musical performance, but that's a different story. But also the formal recognition that punched paper tape could be considered a created work in fixed form. They had no idea what they were doing. But you're too young to remember, but I'm not. I'm old enough to remember in those early days of computer terminals in the 1960s, what were they? How did you feed instructions into them? Punched cards and punched paper tape. And it was by analogy with the punched paper tape ruling of 1911 that some clever man, I don't know who, pursued the case that his computer program was analogous to, and therefore deserved the same protection as, the punched paper tape that powered a player piano. That's how it happened. That's the loophole through which an entire new industry was created long before anybody on the Supreme Court or in lawyers' offices understood what role computers would come to play in modern life.
Was that a Supreme Court decision? I mean, it sort of exemplifies a real dilemma with courts dealing with all sorts of, I think, technology that we're dealing with now, is that they just simply don't have a fundamental understanding of it, and they're literally looking for, well, it looks like that, so maybe it is that.
Well, that's the whole history of copyright that we tell in our book from the very beginning. The first great, how should we say, capture of copyright on by using an analogy of that sort was the British artist William Hogarth, you know, the painter of Rake's Progress and the Harlot's Progress. He argued that engravings were produced on a printing press. Books were produced on a printing press. Ergo, engravings should have the same protection as printed books. That's 1735, and I mean that's where it all started. And copyright has proceeded by such dodgy syllogisms ever since. And the computer software industry owes the proprietary software industry owes its existence really to this long history of dodgy analogies. I mean, you know, everything is like something else in some respect. I mean, you could say a jacuzzi is like champagne because they've both got bubbles. Right. But it doesn't mean to say you should tax them the same. But in copyright law, that kind of argument seems to have held sway, have won the day again and again over 3 centuries in dozens of countries. And it's most peculiar. And that's why we wanted to write the book, to explain to people things don't have to be this way. They've turned out this way by a sequence of really rather bizarre steps.
What ostensibly, the copyright protection is to protect an author, but it has sort of it's sort of not worked out that way, has it?
Absolutely not. No. I think that the claim that the origins of copyright are intended to protect the author is a very angled, a slightly self-interested and often totally hypocritical way of understanding history. What those early copyright laws did between the first Statute of Anne in 1710 and the Donaldson case and then the French law of 1793 was actually to create a vast public domain, because those laws took away from the printer publishers what they thought they owned, which was eternal ownership of the works they published. They gave authors a limited monopoly for 14 or 28 years. So only new creation in quite specific domains was protected and ascribed to the author. Everything else, from Homer to Descartes, was from that point on free to be reprinted in cheap editions without permission and as public property. So that's what I think copyright really was for. And yes, it did create later on in the 19th century circumstances where some people could earn a living by the pen. But there's never been very many who could earn a living by the pen, even under the most liberal domains. Regime, sorry. But what the owners of the means, the today's successors of the old publishing cartels have done, is to turn things back not to the way they were in the 18th century, but to the way they were in the 17th century, because those cartels and corporations now own the vast majority of commercially viable copyrights for a century or more, which is as good as perpetual. That's from my point of view, anyway.
How did it become the case that corporations, whether they purchase it or hire, create a work for hire, have a longer period of time? It doesn't make any sense. Nope. I mean,
No.
I mean, I'm sure there's a reason why, because there's a lobbying power
I'm
there,
not,
but
there's not a reason why. There is a story as to how it
right.
came about. But again, I'm afraid that the book we've written really doesn't pay much respect to the idea that there is an intellectual substructure to copyright, that there is an ideology to it. There's a set of happenstances. The reason for corporate copyright, at least in the United States, seems to have been an extension to book publishing of an idea that was already current in industry. That was called the workshop right, where the owner of the workshop owned any inventions made by his employees when they were on the job. And it applied initially to those complicated works like encyclopedias and railway timetables and circus posters and maps and charts, of which there is no single easily identifiable author, but where they're produced by a whole collection of people. And those were the first sorts of works to be copyrighted in the name of the publisher, and not in the name of a creator. And that seemed to be okay. But that wasn't written into, that was a kind of a practice in the mid to late 19th century. But it was only written into law in 1911 with just a little line in that act, paragraph 62, I believe it is, where it says, for the purposes of this act, the word author shall mean employer.
Wow, nice.
Just one little bit of wording, and that's where it all comes from.